All right, picture this. You've just touched down in Miami. You've booked this absolutely stunning luxury waterfront condo on Airbnb. The sun is shining, the ocean breeze is blowing, and you are totally ready for the ultimate vacation. You step inside, drop your bags, walk toward those gorgeous floor-to-ceiling windows, and suddenly, bam! You slip, fall hard on the polished marble, and your vacation is basically over before it even began. Now you're facing a completely ruined trip, mounting medical bills, and a massive headache. Welcome to our latest explainer, where we're untangling the messy, complicated, and honestly, surprisingly fascinating world of Miami's short-term rental liability. Because if you slip and fall in a Florida Airbnb, who is actually on the hook?
Okay, let's dive into this by comparing two very different scenarios. If you slip and fall in a traditional hotel, liability is usually pretty straightforward, right? It's a single corporate entity. They own the building, they employ the cleaning staff, they manage the maintenance, the whole shebang. But in Airbnb, that is an entirely different beast. You are stepping into this incredibly complex web of divided responsibility. We're no longer just looking at ownership. We actually have to figure out who had control over the hazard and who knew about it. It's a total legal maze, and today, we're going to navigate it together.
Now, to really wrap our heads around the law here, we kind of have to understand the environment first. Miami is gorgeous, obviously, but its specific high-humidity climate, combined with all those luxury aesthetics, creates highly preventable, yet incredibly frequent slip hazards. We're talking about a city with massive humidity and sudden intense rainstorms. Rainwater easily gets tracked right into high-rise entryways. Then you have the finishes: polished concrete, sleek tile, and marble. I mean, they look incredible in the listing photos, but add just a little bit of moisture, maybe from a cleaning crew that just left without putting down a wet floor sign, or some algae buildup on a humid pool deck, and you have a literal ice rink.
Which brings us to the million-dollar question, literally in some of these cases. When that totally preventable hazard puts you in the emergency room, who actually pays the medical bills? It's this high-stakes, whodunit mystery. Because unlike that straightforward hotel scenario we just talked about, the person you rented from might not even own the place. And the person who does own it, they might live in another country entirely.
Let's go ahead and unmask the potential suspects here, treating each one like a distinct layer of this mystery. First up, you have the property owner, who always carries a continuing obligation to maintain safe premises. But peel that back, and you might find the Airbnb host is actually just a tenant subletting the space, even though they're the ones coordinating the daily operations and cleaning. Then you throw in property management companies that oversee the actual guest turnover. And let's not forget third-party vendors, maybe the pool maintenance worker who left a massive puddle or a private cleaning crew. Finally, if you slip in the lobby or by the shared pool, you're suddenly dealing with the condominium HOA. Liability here isn't simply about whose name is on the deed. Actually, scratch that, it's more intricately tied to who controlled the space and who knew the danger was lurking there.
So how does this build into the core of Florida law? Like, how does the legal system actually view you, the guest? Well, you aren't just a buddy crashing on a couch. Under Florida premises liability law, an Airbnb guest is officially classified as a business invitee. Now, why does that legal jargon matter to you? Because it imposes the absolute highest duty of care on the operator of that property. They legally have to maintain a safe condition, conduct reasonable routine inspections to actively look for hazards, and they have to fix them fast.
A lot of these cases revolve around something called a transitory foreign substance. This is straight from Florida Statute section 768.0755. I know it sounds incredibly scientific, but it simply refers to temporary hazards. Think of a spilled drink on a kitchen floor, or maybe condensation dripping from a faulty AC unit onto the bathroom tile. For you to recover damages from slipping on one of these substances, you have to prove that the responsible party actually knew or absolutely should have known it was there.
And this brilliantly illustrates a concept called constructive knowledge. This right here is often the main battleground in these legal claims. If the host didn't physically see the puddle, how are they liable? Well, victims can prove liability by showing the hazard existed long enough that a reasonable person would have discovered it. Imagine a refrigerator that leaks water every single day. Even if the host wasn't there that specific afternoon, they had constructive knowledge because it's a regular, foreseeable issue that they completely ignored.
Now, what's really interesting about this slide is this single number, 50%. It is an absolute game changer. You see, going into 2026, Florida operates under a modified comparative negligence rule, and this number is the absolute threshold for your case. It completely rewrites the rules for personal injury claims in the state, and it carries huge shock value if you aren't prepared for it. Here is the harsh reality of how this law actually works.
Let's say a jury decides that you are partially at fault for your own fall. Maybe you were running or staring down at your phone while walking. Your compensation is reduced by your percentage of fault. But, and this is crucial, if you are deemed to be more than 50% responsible for the accident, recovery is strictly not permitted. You get absolutely zero compensation, nothing. This is exactly why defendants will fight tooth and nail to shift the blame right back onto the guest.
One of the main ways property owners try to shift that blame is through something called the open and obvious doctrine. They'll argue, hey, that puddle was right in the middle of the floor. Anyone with eyes should have seen it and walked right around it. But the law is far more nuanced than that simple excuse. Even if a hazard is glaringly obvious, courts will look at whether it still posed an unreasonable risk. If an entire hallway is flooded and there is literally no other way to reach your bedroom, the owner might still be negligent. Why? Because they should have anticipated you'd be forced to navigate that exact hazard just to use the property you paid for.
So, the crucial point is understanding the incredibly heavy burden of proof placed squarely on the injured guest. To actually win a case, you have to successfully hit all 5 of these steps. 1. You must prove a dangerous condition existed. 2. Prove knowledge, that the host or owner knew or should have known about it. 3. Failure to act, meaning they didn't clean it up or warn you. 4. Causation, showing that specific puddle is exactly what caused your broken ankle. And 5. Damages, proving you suffered measurable financial or physical losses. If you miss even one of these 5 steps, the entire case falls apart.
But how do you prove those 5 steps? With rock-solid evidence. And listen, you have to move fast. Airbnbs are super high-turnover environments. The cleaning crew is going to come in the very next morning, mop the floor, and wipe away the hazard entirely. Your evidence literally evaporates. You need photos and videos of the hazard immediately before it dries. You need to secure the building's hallway surveillance footage. You absolutely must save your booking confirmations, take screenshots of your messages in the Airbnb app complaining about the leak, and of course, secure all medical records right away. Time is for sure not on your side here.
Now, you might naturally be wondering at this point, can't I just sue Airbnb? Well, typically, no. Airbnb legally operates as a platform, just a middleman connecting you to a host. They usually aren't directly liable for the physical property itself. However, they do provide something called air cover for hosts. This includes liability insurance that may apply to guest injuries. So while Airbnb the company might not be the direct target of the lawsuits, their insurance policy can serve as a really vital source of compensation.
Okay, so let's say you do successfully prove your case. What exactly are you entitled to recover? Florida law breaks this down into distinct categories. First are economic damages, the hard numbers. Medical bills, future rehab costs, and lost wages from missing work. Then there are non-economic damages, which compensate for the very real pain, suffering, and the massive emotional distress of having your life upended by a severe injury. Finally, in rare cases of extreme intentional misconduct or gross negligence, courts can award punitive damages to financially punish the responsible party.
But there is a ticking clock on all of this. 2 years. As of 2026, the statute of limitations for filing a negligence claim in Florida, including a slip and fall, is strictly 2 years from the exact date of the incident. If you wait 2 years and 1 day to file your paperwork, you completely lose your right to pursue compensation. The door closes forever, no exceptions. All right, let's turn this into an actionable toolkit to protect yourself. If you do take a fall, follow this exact playbook. Number 1, seek medical attention immediately. Your health is absolutely paramount, and doing so creates an official medical record right from the start. Number 2, document the scene with your phone camera before anything gets moved or cleaned up. Number 3, report the incident in writing to the host directly through the app. Number 4, preserve all of those communications and photos securely. And finally, number 5, consult a qualified Florida personal injury attorney. Firms like the Farber Law Firm down in Coral Gables specialize in evaluating these super complex premises liability cases and figuring out exactly who is at fault. So we'll leave you with this thought to ponder the next time you are browsing luxury vacation rentals. Is the convenience of an Airbnb worth navigating a legal maze? As we've seen today, right behind those beautiful listing photos and easy booking apps lies a really complex intersection of premises liability, multi-party responsibility, and some very strict legal thresholds. Knowing your rights and exactly what to do if things go wrong is definitely the best insurance you can pack. Thanks for joining us on this explainer. Stay safe out there, watch your step, and keep asking the right questions.